Okay, great. Hi, welcome everybody. My name is Dave Henry. I'm here to talk to you for about an hour and a half on mediation advocacy, and the title is Inside the Plaintiff's Caucus Room. I am excited about this topic. I've been wanting to teach this for a long time. Just a couple of housekeeping items before we get started. Hugo is my co-presenter, and he'll be monitoring some of the chat room. I also have the chat box open. Your line should be muted, but you have the ability to unmute your line if you need to ask a question, or you can do it in the chat box. Either one is fine with me. It might be more comfortable just to put it in the chat box. If I don't get to your question in the chat box, it's either because I'm going to cover that material later on in the seminar, or it may just be the kind of question that requires a longer conversation offline, and then I'll address it. But I'll try to get to every question I can, if not during the seminar, then immediately thereafter. About 75 minutes in, Hugo will post the CLE number. This course is actually qualified for 2.5 hours. I don't know how it got qualified for 2.5 hours because it was submitted as 90 minutes, but I think maybe it got closer to 120 in the eyes of the bar, and so they gave us 2.5 hours, and I don't think anyone's going to complain. But that's the reality of what the bar did. So maybe it's because I packed so much material into so little time. Although I do tend to talk very quickly. I was in front of the Florida Supreme Court several years ago arguing a case, and we had two different lawyers arguing the appellee's position, me and somebody else. So we only had 20 minutes between us. And Chief Justice Parente at the time said, "Mr. Henry, I want to compliment you on packing 30 minutes of argument into 10 minutes. What she didn't know was that I had 3 cups of Cuban coffee in the attorney waiting room, and ours was the last case to go. So I was jacked up beyond belief. So I know that I can talk pretty quickly if I need to. All right, let's talk about big picture first. If you've been, and thank you. I see some familiar faces and some friends and some new folks too, so welcome. I always like to talk big picture first, sort of, because I feel if I don't give you sort of the philosophical underlayment, I don't know if that's the right word, underpinning of what I'm trying to do here, then I don't think the stuff sticks as well. So I try to give you the view at 30,000 feet first. Mediation is really hard to teach. This has been one of my themes that I've been talking and speaking about, and it's hard to teach because we're rule-based animals. Lawyers are rule-based animals. You spend your whole law school career learning a variety of rules: substantive law, procedure, evidence, ethics, judicial administration rules, all sorts of different kinds of rules. And then we come to mediation, there are no rules. So why would somebody who's really good at navigating between rules be good at extemp, right? It's like extemporaneous speaking versus if you have a script. Well, scripted actors and extemp performers are very different kind of animals. There aren't very many people who can do both really, really well. Some can, but they're two different skill sets. And so the things that we do as lawyers, the things that we learn as lawyers, the art of lawyering in the traditional sense really isn't very helpful in mediation because you're not amassing evidence, you're not working within the bounds of trying to dismantle an expert or anything like that. So when you start thinking in those terms, you go, wait a second, mediation really turns on a completely different axis than litigation. So we need a different set of skills. Unfortunately, we don't get those skills in law school very often. There's very little education in dispute resolution, and we sort of just get thrown into the deep end of the pool as lawyers. And most of what we learn in terms of mediation advocacy, performance during mediation, is just habit and ritual that we've learned from somebody else. We're probably mimicking somebody else's behavior. In my case, it was the partners that I used to work for when I was a young associate. I just watched them. So whatever they did, I pretty much mimicked that. And as I got older, obviously, I gravitated into my own skin, my own shoes, so to speak. But most of what we do is unexamined habit. And that's one of my frustrations, because some of the things that we do as a function of habit or custom, when critically examined, don't really stand up very well. And so I will constantly kind of keep breaking the glass, so to speak, and thinking, maybe we need to think about this in a different way. So I asked the question, how do you export teachable moments from a confidential and privileged proceeding? Well, you really can't. I mean, in other mechanisms, in other places in the law, we have feedback mechanisms. When the judge denies your motion, that's a feedback mechanism. It wasn't a very good motion. Or if the judge overrules your objection, that's a feedback mechanism. The client doesn't pay your bill, that's a feedback mechanism, right? I mean, those are feedback mechanisms. And we don't have any, because you go to mediation, you do whatever you do in there, and you either come out with a sheet of paper or you come out with an impasse. And there's really very little, in my experience, very little post-mortem on what went on in the room. And you can't record it, you can't videotape it. You know, you can go to these NEDA programs and these other trial advocacy programs, and you'll have 15 people in the room watching you and critiquing you on everything you do, your opening, your closing, all that stuff. That's all wonderfully useful, enriching information. You don't have any of that in mediation. We start thinking about the enormity of that. We don't, we learn in certain ways, and mediation doesn't give us the ability to read a transcript or see a recording, see a video. We can't do that. So it's really hard to export teachable moments. That's why I think we have to talk a lot more outside mediation about what goes on inside mediation, because that's the only time we can do. We can't do a real post-mortem in the way that we'd like to do. I've toyed with the idea of going to the bar and saying, hey, could we get some people to agree to be videotaped while they're doing mediation, which raises a whole spectrum of issues. But I think it'd be fascinating and hugely beneficial if we could ever get a pilot project like that off the ground. But I don't think it's going to happen for a lot of reasons. So big picture again, most of what we spend our time doing as lawyers, first as law students, then as younger lawyers, then as older lawyers, is trial-centered practice, right? If you're a litigator, it's a trial-centered practice. Everything's leading toward trial. You do your interrogatories, your depositions, you use all your discovery tools, which were designed for trial. Discovery tools weren't designed for mediation. That's a funny little thing. And they're not necessarily the best ways of getting information that you need to mediate. We spend a lot of time thinking about trial prep, but the reality is we know that less than 2% of the cases go to trial. Some people are telling me the data, and this is pre-COVID. Pre-COVID, it was less than 2%. In some jurisdictions, they're telling me it's less than 1%. And I was at a firm with 500 lawyers, and we had offices in 20 states, and I mean 20 cities in 6 states, and the data was the same in every jurisdiction, whether it was Philadelphia, New York, Miami, Orlando, less than 2% of cases. So my question is, why are we spending so much time on trial and trial advocacy and trial theory when the overwhelming majority of cases are going to resolve through mediation? That's the thing you need to be good at, because that's the thing that's either going to get you the recovery that you want if you're a plaintiff, or get you out of the soup if you're a defendant on, economically reasonable terms. And so maximizing your competence in this area should be a priority. But as I said before, the problem is it's really hard to teach mediation advocacy because we don't have all the tools that we would normally have. Does anybody think that the number of trials is going to increase from pre-COVID days? I don't think so. I think there's going to be a bump because in some jurisdictions like Orange County, where I'm from, they've implemented some new administrative orders, which are intended to create some case management orders, which are intended to streamline the process and put the cases on the trial docket within 12 to 18 months. That's a brand new administrative order, just came out of Orange County, and I expect other counties are going to do something similar. So what, of course, you're going to have is about 18 months from now, you're going to have a big bubble because everybody's going to be on the flight path, right? Everyone's going to be on the runway. You're going to have a bunch of planes stacked up waiting to lift off, and so you're going to have a bubble. I don't know how they're going to address the bubble with senior judges or whatever, but the point of it is, mediation then becomes even more important because we got to deflate the bubble. We got to burst the bubble, and the way we burst the bubble is either we enter more summary judgments, which are parenthetically actually could happen because remember we just changed the rule governing summary judgments, which is sort of interesting, but I don't think it's going to move the needle that much. Okay, but maybe a few percentage points of cases resolved. But we're going to burst the bubble by being really good at mediation and using mediation more efficiently. My criticism, and this is an aside, not in the outline material, but I think it's really important, and I'm going to write about this next month in my blog. My criticism of the new administrative order in Orange County and the others like it is that in the order, it says mediation should be completed within 30 days. It says you can do an early mediation, that's fine, but it should be completed within 30 days after the end of discovery. That is not what I was hoping the court would say. That is not optimal. What we want to do is say you should have the mediation completed within 120 days of joinder of the parties and a second mediation if the first isn't successful. And we can't seem to get that. We can't get through that. We can't make that paradigm shift. Why is this? Why are we so stuck on one mediation in a case? You take 10 depositions, nobody complains about the cost. No, you send out 3 sets of interrogatories or whatever, or 3 sets of requests for production, nobody complains. But if you suggest 2 mediations, it's like, wow, why would we ever do that? Why wouldn't you do that? why wouldn't you give your client a chance to settle the case? Because oftentimes early in the litigation, the case is different. The case evolves, it changes. The parties get litigation fatigue, they run out of money, they run out of interest, they got other personal needs. Things change during the course of a 6, 9 month, 2 year case. And so if the needs change, then the need to settle may change. And that oftentimes occurs if one side or the other has a more compelling reason to settle than they did before, or both sides now have a compelling reason to settle that didn't have before, sometimes for reasons outside the merits of the case. So my frustration with these administrative orders is that they're putting the mediation at the end of the discovery period, which is a problem, because one of the things that happens in mediation, if you don't settle the case, is invariably you learn something new, and that something new oftentimes makes you want to take some additional discovery. Oh, you find out about a witness that might be important. There's an item of damages that you need to investigate further. There's an expert you might need you hadn't anticipated. There's whatever. And if you put the mediation after the end of the discovery period, you're inviting legal malpractice. Because what happens in mediation is you cure the malpractice sometimes because something comes to light. Either the mediator or somebody raises an issue or thinks about a defense or thinks about something, and oh yeah, that's a good idea. We need to investigate that. And then you don't have time if the mediation is at the end of the discovery period. So you're going to see more of those case management orders, and in my view, they're fundamentally flawed because they don't understand the advantage of early mediation. You don't need a ton of discovery to mediate a case. You need a ton of discovery to try a case, to know what the witnesses are going to say, but you don't need a ton of discovery. You don't. And I've worked for institutional clients and carriers that had early mediation programs, and they were highly successful. But culturally, we don't do that. And we're going to talk more about that later on. Why doesn't that happen? But that's sort of big picture for me. We need earlier mediation, and we need to make sure that we become better at mediation advocacy. And that's why I teach these kind of classes, because I think it's pretty important. All right. Let's talk real quickly about selection of the mediator and timing. We can go on. We could do an hour or two on this, but we're not going to. Here's the thing. Sponsorship theory says you want the mediator that the other side wants, not the mediator you want, because you want the other side to have trust and confidence in the mediator. So when the mediator comes in and says, this is all they got, or this is the least the plaintiff's going to take, that message is communicated and accepted by the other side. If I'm a defendant, I say, that's all I got. And the mediator goes in the plaintiff's camp and says, that's all Henry said he's got. I think he's telling the truth. If that mediator is a trusted confidant, the plaintiff's going to believe that, and they're going to take my number, even if I'm lying. Okay. And it works the other way. So having the other side really trust the mediator is really important. And then thinking about the personalities involved, who's in the case. Are we dealing with some pretty hard-headed construction guys that are, need a little bit of, muscling around? Are we dealing with a case that requires a certain level of sensitivity? I do some sexual harassment, discrimination cases. My tone, my demeanor is different in those cases than when I'm doing construction defect. It just is. It has to be, because the personalities that I'm dealing with are different. And so when you pick your mediator, you got to think a little bit about who are the personalities in the room. You got to think about race and gender, and you got to think about, if it's a sexual harassment case and the offender is a middle-aged white guy like me, and the offended party is a black female under the age of 30, I'm not sure I'm the right mediator for that case. Okay, maybe you need a female mediator. You got to think about who are the personalities in the room and who might best deliver the message. And so I spent a little bit of time thinking about that. And then the other thing I stress, and mediators get in this argument all the time, but I think subject matter expertise is really helpful. I know that when I'm mediating in my wheelhouse, whether it's IP or it's catastrophic personal injury or it's non-competes or employment, when I'm in my wheelhouse, I think I can do a better job, because I can pick things apart and I can create some doubt in the other room. I can create some uncertainty, and I can push back on some things that I think are not as certain as people might believe. And I have the ability to push back when I'm in my wheelhouse. So subject matter expertise is really important. I think it's underrated, but I think it's pretty important in a hard case, not in a simple case, but in a hard case. Okay. This is the other point I made. Why are you setting mediations based on some arbitrary case management order? The judge puts in there and says, have your mediation, 30 days before trial, 60 days before trial, 30 days after the discovery. This is an arbitrary date because it doesn't bear any relationship to what's going on in the case. What motions might need to be done, what discovery needs to be done, how much money do the parties have, what are their time constraints, What are their personal lives, their personal pressures? It's ignorant of all those things. It's just a date the court sticks in there. Don't put your discuss. Think about if I'm a defendant, when's the best time for me to get into the plaintiff? If it's a catastrophic personal injury case, if I get to the plaintiff sooner, I can sell that case cheaper. The studies show that all the time. If I got a medical malpractice case and I've got a baby who died during delivery, that's a case you don't wait 2 years to mediate. You don't wait till the end of discovery to mediate that case. You get in immediately. So it's really important that we think about timing. Okay. And why are lawyers hesitant to engage in early mediation? For a lot of reasons, because they don't want imperfect information. They want more information. They want to know what everybody's going to say, what the experts are. They don't like giving advice based on uncertainty or doubt or having to hedge or having to qualify. And what lawyers have to get past is this idea that you don't need perfect information to mediate. Clients make decisions all the time with imperfect information. Business owners make decisions all the time with imperfect information. Parents make decisions all the time with imperfect information. Should I put my kid in this school or that school? Should I buy this piece of equipment or that piece of equipment? Should I open up a new office here? Everybody deals with imperfect information. The law is no different. You don't need perfect information to mediate a case. And so we have to sort of start teaching people that early mediation is better. And here's the other thing. No client complains about the bills if you've given them an opportunity to mediate and they didn't settle the case, and then you start having to bill them for the time that you're spending preparing the case for trial. They can hardly complain if they were given the opportunity to settle the case and they chose not to take advantage of it. Okay, a couple other things. So let's talk about authority. Now the class is the seminar is called Inside the Plaintiff's Caucus Room. And I say, well, what? And we talk about authority. It's not almost never a problem for the plaintiff. The authority problems happen on the defense side when there's insurance coverage typically involved, or the absence of insurance coverage. That's when the authority issues rise. But I mentioned this topic because in the plaintiff's camp, about every 3 months, I'll get a plaintiff's attorney who will say to me, Dave, I'm upset because I don't think they have enough authority in the other room. I don't think they brought the right person who has enough authority. This person is, not able to respond in the way that I think. And so, they're not able to, my demands within the policy limits. They should have had somebody here with policy limits. They clearly don't. And, I say, well, what do you want to do about it? There's nothing I can do about it. I'm a mediator. What am I going to do about that? I don't determine who they bring. I don't have the ability to police who they bring. You say, well, I'm going to file a motion for sanctions because they don't have proper authority as defined by Rule 1.710, which, requires a carrier with the limits, with authority up to the limits or the demand, whichever's less. And so they say, well, I'm going to file a motion for sanctions on the mediation rules. Okay, well, guess what? If you file a motion for sanctions on the mediation rules saying that the adjuster said, or the client said, or somebody said, I don't have the authority to accept that offer, or some information comes to you which leads you to believe that the other side doesn't have proper authority, and you file a motion for sanctions under the mediation rules saying, I want the cost of mediation, et cetera, et cetera. If you talk about statements that occurred during the mediation process, right, you're violating the Mediation Confidentiality and Privilege Act. You can't talk about what was said during the mediation. There's only a handful of exceptions, and there's no exception for statements related to the presence or absence of authority. That's not one of the exceptions to the confidentiality statute, Chapter 44. So when they amended the Rule 1.710, they didn't amend the statutory privilege and confidentiality. Nudge, nudge, little wink, wink. It doesn't say anything about that in the civil procedure rules either. But the people who drafted the rules back in the 80s, late 80s, early 90s, they knew there was a problem. They just ignored it. I talked to some people on the Rules Committee back then. They knew the legislature needed to amend the statute to create a mechanism for enforcing the lack of authority, because you can't assert lack of authority in a motion. But you can't assert statements made during the mediation process. So there's a little bit of a funky problem there. So I tell my plaintiff's attorneys, I go, you can't file that motion. Under my view of the rules and laws, you can't file that motion. Okay. I don't know how you're going to prove the absence of authority. You can't do it through the mouth of the adjuster or the mouth of the client. A couple other quick issues for plaintiffs in particular. Not so much a problem on the defense side, but more on the plaintiff and plaintiff personal injury, to be sure, is the bigger problem. Corporate America, not a problem. Your lay, your run-of-the-mill lay personal injury plaintiff, you've got to do a better job as plaintiffs of paying attention to your Zoom, your video, your audio, your lighting. You've got to do a better job of that. There's nothing more off-putting to a mediator than when I'm struggling to listen to you as the plaintiff's attorney because you got a slow internet feed, or and you're balking, or you're halting, or whatever you call that, stuttering, whatever that is, and your audio is not good, your video is not good, or your camera angle is not good. I spent a fair amount of time. I mean, I know this, it takes a lot of time to look like this. You know what I'm saying? I mean, this doesn't come easy, okay? So I spent a little bit of time on my background, on my lighting, and that sort of thing. Hugo and I were talking beforehand. Nobody has yet come up with a fix for the fact that the circle lights refract off your glass lenses. We haven't figured that problem out yet. Somebody's going to invent some glasses or something. There's Zoom glasses or something. Maybe somebody already has, but in fact, I'm going to Google that and see if someone's got Zoom glasses. But that's a problem. But other than that, I talk about clothing, lighting, sound, the video. I wrote a blog piece on this. I cited in my slide here called "The Convention of the Witch and the Princess." Very important that your plaintiff come off looking very, very good. We used to say, wear your Sunday best or whatever. I'm not sure that's PC anymore, but that's what we used to say. So make sure your plaintiff looks good, presents well, and then think real hard about having the plaintiff in your office next to you if you're the plaintiff's attorney. I think your client control issues, your managing expectations is easier. If the things get emotional, it's easier to manage. I think it's really important for the plaintiff to be in the room with their attorney, even if they're appearing by Zoom. That physical proximity between lawyer and client is pretty important, I think, on the plaintiff side. I think much more so than the defense side, because the defense side, you typically have corporate actors or somebody who's used to being sued or has been sued before, or has a level of sophistication maybe that doesn't necessarily need the hand-holding. But I think on the plaintiff side, I strongly encourage that you be physically present with your claimant. If you're a plaintiff and you're in a multi-defendant case, you've got to think real hard before you enter mediation. What do I need to do to tee this case up to make sure every defendant has a reason to settle? And I've written blog pieces about this too. And this is the problem of the little toe, right? You have litigation, and you got the big toe and the second toe and the little toe, the pinky toe, and the pinky toe gets ignored. You're not paying attention to that defendant. You're paying attention to the two lead defendants, and there's a third or fourth defendant you're not really paying much attention to, because frankly, from a liability standpoint, they're kind of throwaway defendants, or they're not real critical. Then you come to mediation, you go, well, I want them to contribute. Well, you haven't been doing anything during the litigation to suggest that these folks have any significant exposure, and so their pocketbook gets real tight. You have to figure out a way to put pressure on all your defendants before mediation to give them incentive to settle. And what I see too often is plaintiffs' attorneys, because they're thinking about trial, and they're thinking about how they're going to prosecute their case, and they're thinking about where the challenges are. They're focused on the key defendants for trial purposes, and they let the other defendants off the hook, so to speak, from a discovery standpoint, and they're not feeling any pain. And so I tell plaintiffs' lawyers is you got to inflict pain on everybody. You got to inflict some pain on everybody before the mediation to get maximum value. If you ignore somebody for 6 months of litigation, and then you show up at mediation, you go, why aren't they contributing? Well, because what message did you send them for 6 months? You sent them a message which is, I'm not really that concerned about you. If you're around the trial, great, but I'm not really going to spend a lot of time on the case in chief against you. And then you say, well, they should be kicking in a third. No, they shouldn't. They're going to be the 2% guy at the end of the mediation process. So you've got to think about that. And then the other thing, I think about early mediator involvement in the complicated case, in the bigger case, to make sure that defendants have got everybody that needs to be there. I can't tell you how many times, either as a mediator or as a co-defendant in a complex case, whether it was construction, aviation, med mal, whatever I was doing when I was a younger lawyer, somebody didn't have the right person at the mediation. Somebody didn't have the right carrier representative. Someone didn't have the corporate CEO. Someone brought some mid-level manager, or somebody brought an in-house counsel who wasn't ultimately the decision maker, and you didn't have the right bodies. And so the thing I tell plaintiffs' attorneys, and it sounds maybe obvious, but it gets overlooked, you really need to focus on who's coming to mediation. It's a 30-second phone call. You call the other side. You talk a little bit about logistics, timing, et cetera. Hey, by the way, who you bringing? If that person doesn't sound like the right person in your mind, you have a conversation about it, right? That's all you can do. You can't force them to bring somebody, but you can sure reach out. And if you don't like the answer you're getting, you reach out to the mediator. You have the mediator do a little digging, a little poking. And I've done situations where, okay, you tell me you're bringing Steve, but he's not really the principal. There's another guy, but he lives in California. Well, can we have the other guy available by telephone? Right now with Zoom, this problem has been largely ameliorated because we can get everybody in pretty quickly. But in the old days, it was harder. the great thing of one of the unintended consequences of Zoom is that we have reduced the likelihood that we have the wrong actors. We reduce the likelihood that we don't have the key decision maker. We increase the likelihood we have key decision makers through Zoom. So in that sense, Zoom has become much more effective, because if I got a corporation with multiple levels of management and I really want the president there, he doesn't want to fly all the way to Florida, but he or she don't want to fly all the way to Florida, but they might Zoom in for a couple hours, and that makes it a little easier. So that's a couple of things to think about if you're a plaintiff. For plaintiffs, it's like you really got to think about this like a dinner party. It's a really big dinner party, and you got to think about the chairs and the seating and who's going to be there and what do I need to do in advance to make sure everybody likes what's being served up. Okay, a couple of other things I want to mention. And this is one of those things that I don't understand why it doesn't get done, but it doesn't. I can't. And what I'm talking about is distributing a position statement to the other side in advance of mediation. If you're a defendant, you're probably getting paid by the hour. And so writing a letter to the plaintiff's camp in advance of mediation, laying out how you see the case, where their problems are, where the thorns are, where the weaknesses are, how difficult their case might be, just sort of teeing up some of the issues that you're going to address in mediation would be hugely helpful, because plaintiffs aren't going to digest all that in opening session. I mean, what we're talking about is managing the plaintiff's expectations. And you start that process well before the mediation by writing a thoughtful pre-mediation statement to the plaintiff's attorney, not the mediator, to the plaintiff's attorney. You can copy me on it, but don't write me a confidential privilege statement and don't send anything to the other side. That's a hugely wasted opportunity. And this is one of those pristine, classic examples of unexamined habit and ritual that started back in the 1980s. Because I was my generation of lawyers, I entered the bar in 89. The Mediation and Confidentiality and Privilege Act was passed in 1985. So my generation of lawyers was the first generation of lawyers to travel under this new mediation statute, not so new now, right? And what happened was, because we said it was a privilege and confidential proceeding, everybody started sending privilege and confidential letters to the mediator. It was sort of a natural corollary to the statute, right? If this is all confidential, and then I don't want to send anything to the other side. Well, you absolutely want to send something to the other side. And you can do that within the ambit of the privilege, because the privilege not only protects communications during the actual mediation, but it protects all the communications leading up to mediation. All you have to do at the top of the letter is say, this is a mediation communication under chapter 44.405 at sec. And it's privilege. You subsume within the privilege. So nothing you say in a letter can be used against you in a litigation. It's a huge opportunity to address the plaintiff directly. And plaintiffs, huge opportunity for you to educate the defendant. If it's a personal injury case, talk about the injuries to your client. How is this a unique case? The challenge for plaintiffs is to make their plaintiff distinct, make their claim different, make the case stand out. Tell the defendant something that's not obvious. I'll give you a simple example of something that happened in mediation. There's a BI case, not a big value case. We're talking to this lady, and she lives in Tallahassee, and I go, what do you do, in your spare time? I'm talking to her during one of the caucus sessions. What do you do in your spare time? And she says, well, I take care of my sister. Oh, well, tell me about that. Well, she's a double amputee and she lives in Orlando. And whenever she goes into diabetic crisis, I have to get on a bus and come down and take care of her. I go, well, that's really quite eye-opening, and must be hugely difficult for you. And she goes, yes, it is. Yes, it is. And I said, and the plaintiff's attorney didn't know that about his client. I thought, what a great fact, right? And she says, well, it's really hard for me to take care of my sister now because I can't move her and lift her like I used to. That's a huge fact. That's a great fact, right? That's the kind of information you got to dredge from your client and put in the pre-mediation letter so you can particularize your plaintiff. If it's a corporate case, if it's a business dispute, if it's an IP dispute, if it's a construction case, what is it you need to know, defendants, about our case, which should give you pause, give you concern? And you're going to revisit those themes, those comments, those arguments, those bullet points during the mediation session, but you've got to set the table in advance. Why wouldn't you? Why would you count on defendants to correctly evaluate the case at mediation? What if they've overlooked something? What if they're missing something? What if they don't understand something as well as they should? You as the plaintiff need to start setting the table and make sure the defendants have enough money up on the case. make sure that they are prepared to come, make sure they got the right parties. I see plaintiffs, one of the biggest mistakes I see plaintiffs make is they don't send a demand. They don't send a demand. Well, how is the defendant supposed to know how much money they're supposed to bring, or even try to approximate that? What if I think it's a $100,000 case? And so I tell my client, well, maybe it's a $100,000 case. If you bring 60 or 70, you probably get it done. And it turns out the first demand is $450,000 for reasons I didn't even appreciate before, because you hadn't answered discovery very well, or maybe I hadn't taken a deposition I should take, whatever. The point is, if you're a plaintiff's attorney and you don't communicate your case to the other side, you're missing a huge opportunity. Because in a corporate world, the case that has the most noise gets the most money up. Silent cases don't get money up. Reserves don't go up. Budgets don't go up. Board meetings don't get called if you're silent. If you write a letter in advance of mediation, a big case, someone's got to talk about that letter. Defense counsel, corporate counsel, insurance carrier, board of directors, whatever it is, someone's got to talk about that letter. And if they're talking about that letter, then chances are they're going to put more money on the file, not less, right? You'd have to write a pretty stupid bad letter for the money to go down, right? I mean, you think about that. So it's your chance to bump up the reserve, to bump up the anticipated legal spend. And people don't do that. I know why contingency fee plaintiffs don't do it, because they don't get paid to write letters. But shameful defendants not to do it because they get paid to write. That was the first lesson my old boss, Walt Ketchum, told me 30 years ago. He goes, how can a client ever complain that there's not enough? You didn't keep them apprised of litigation. You didn't update them on the status of the case. They pay us to write these letters. They pay us for that. There should never be an absence of paper in our file. It's just silly. Now, the contingency fee side, I get that. You don't get paid to write, but you got to make that part of your practice habit. If you're a plaintiff, you've got to write to the other side and particularize your case. Think about what is this? What don't they know? What should they know? What's driving this case? Those are really good questions to ask yourself. And you're going to revisit those themes in the mediation, but don't just start with new information in the mediation. That's ruinous. New information in mediation is ruinous because nobody has time to vet it, analyze it, talk about it. It's not good. It's not good. Surprises in mediation are not good. Okay.
David, before we go further, someone asked, how should you respond if you get one of these letters?
Oh, that's a good point. Yes, excellent point. So if you get a letter from plaintiff's counsel, and I talk about this on my blogs, you should write back. What I'm hoping will happen will be a conversation in writing between the both sides. And if you're a plaintiff and you send one out to defense, I always do one. Even if the plaintiff doesn't send me one, I send one if I'm a defendant. I go, dear, and I write it for the plaintiff. I write it for the plaintiff, not the plaintiff's attorney. I address it to the plaintiff's attorney, but I write it to the plaintiff as if because I want that plaintiff to read that. Or if I'm the plaintiff, I write it for the defendant. I don't write it for whoever the payer is, the carrier or the defendant. I write for the checkbook if I'm the plaintiff, not the lawyer, not the mediator. I don't get into legalese if I'm writing to the plaintiff. I don't get into summary judgment. First of all, let me just say something. Nobody on the plaintiff side ever believes they're going to have summary judgment entered against them. They don't. There's never been a plaintiff in the history of the world who thought there was going to be summary judgment entered against them because the lawyer wouldn't say you're going to get summary judgment entered against you in this case is a bunch of nonsense. They don't think that for a second. So talking about summary judgment in a position statement might be okay. It's pointless. It just is. It's just pointless. It's not what's going to motivate the plaintiff to settle the case. Okay.
And so when you get that letter, then you respond how?
And with a letter back. That's why I want to, if I'm the defendant, I want to solicit the letter from the plaintiff 30 days in advance or more if possible, and including a demand. And I want the plaintiff, I will ask the plaintiff for a demand. I don't care what the number is. I really don't care. The reason I'm asking for the letter and a demand is because what that does is it requires a plaintiff's attorney to talk to his client before he sends out the letter and to get the demand. And what I'm really doing is I'm causing a little caucus to occur before the mediation. And why is that necessary? Because oftentimes the plaintiff's attorney and the plaintiff don't talk well in advance of the mediation. Might meet a couple of days before, but they don't have a long conversation. And what happens is if the client is out of control, right? The plaintiff's attorney is going to figure that out because he's not going to be able to send the letter because the client's not agreeing to the demand. It's a way of vetting, finding out whether we got a problem with this plaintiff. I'm helping the plaintiff's attorney help himself by forcing him to communicate with his client in advance. Or And if I send them my defense letter, here's the other good thing. And plaintiff's attorneys have told me this, Dave, I like it when you send me the letter because I don't have to be the bad guy with my client. I just show them the letter and go, these are all the things they're going to say about you in the case. I don't have to be the bad guy and beat up on my client, but it's useful leverage for me because I can manage my client's expectations. See, once you start thinking in these ways, you realize it has very little to do with lawyering. We're not talking about lawyering now. We're talking about figuring out ways to motivate people and challenge people and instill doubt and fear and uncertainty and all those things that we use to get the case resolved. Okay. So meet with the contingency fee client at least 10 to 14 days before the mediation. If you have client control issues, better to find out then on the day of mediation. Day of mediation is hard to fix client control issues, but if you got client control issues, you bring in a partner, you bring in one of your colleagues, and you have another sit down with them. I've had that happen numerous times. Also, if you're a plaintiff's attorney, you need to draft a mock closing statement, particularly if you're a contingency fee. What does a $100,000 settlement look like to you? What does $200,000 look like to you? Oftentimes the plaintiffs don't understand that. And talk about the cost, the fees, the expenses, the liens. They need to know what the net looks like. And you show them different price points of settlement so they get some sense that there's not just one number out there. There could be multiple numbers out there at the end of the day. That's pretty important for plaintiff's attorneys to do a mock closing statement. I will do that as a mediator if I don't think the plaintiff's attorney has done a very good job of that. I'll say, hey, Steve, why don't you, while I'm in the room with the other side, why don't you maybe go through a little mock closing statement with your client at different price points and think about that? And they do that. And it's sometimes very helpful. Okay. So we talked about sending a letter before the meeting, explain, well, two letters. There's two letters to go out. One is I do a letter to the client saying, what is mediation? How does that work? What goes on there? The second letter goes to the other side. Okay. Those are the two letters that I send. I have a form for that. You can ping me for an email if you want to see what my mediation letter to the client looks like. It's sort of a one size fits all. I think it's pretty good. I worked on it for a long, long time. So it's not perfect, but I think as a one size fits all, it's pretty good. Okay, let's talk about dispensing with opening session. Occasionally, someone will think about, well, maybe we should dispose with opening session. Here's my rule of thumb on that. Unless there's some compelling unless there's some real pretty fear that the mediation process is going to be derailed and the parties cannot maintain a certain level of civility. If I think there's a potential for a grenade going off in the room, then yeah, we probably don't want to do opening, but that's a very small percentage of cases, very small percentage of cases. I mean, if it's, like I said, if it's a sexual harassment case, yeah, I probably don't need to have the harasser at the mediation, much less in the opening session. I hear employment lawyers tell me that you brought the harasser to the mediation. Why would you do that? Well, he's the CEO. Well, that's a problem, isn't it? I mean, you can't do that. So don't dispense with mediation just because you get a little bit, don't dispense with opening just because you get a little bit of grousing. Oh, I don't want to see them. Too bad. I want you to have to sit in the other room with those people because I like that level of uncomfortableness, because that level of uncomfortableness promotes settlement. I say as a mediator, hey, how'd you like sitting in the room with those people? I hate those guys. I don't want to see them again. Well, guess what? If you don't settle the case, you're going to be seeing them for a long time, including 2 weeks in circuit court. And I always like to use that line. This is your chance to unbundle yourself from these knuckleheads, and you need to take advantage of it. And so I like making people uncomfortable. Fortunately, it comes very easy for me, as my wife has told me. So it's not a problem. So making people uncomfortable is a good skill set to have if you're a mediator. Okay, so if you're a plaintiff's attorney, make sure you explain the role that they play, the client plays. The lay client doesn't understand. This is not, you're not under oath. You don't have to answer my questions. You can ask me to leave the room. There's all those things that we know that are just sort of common sense to us. A lot of times plaintiffs don't know. They've never been in litigation before. Never been in mediation before. So things like, how can you hurt? Well, you can hurt by saying, when we're in the middle of negotiations and your lawyer demands 200, and then you as a client say, yeah, but I probably want to take 150. Shh, shut your mouth. Why would you do that? And claimants do that, and defendants do that. Defendants do it too. They go, let's offer 50. And the other one says, no, what about 75? Well, why would you say that? Right? You just gave me information. So telling them to keep their mouth shut is a pretty useful thing. And it sounds a little harsh the way I say it, but it's pretty important if you're a plaintiff to keep your mouth shut. Because most of the time, the things that are coming out of your mouth are not going to help you. Unless it's a good story about your injuries or your damages or things you can't do, then you can help. But on other things, not a good idea to talk a whole lot. And again, we talk about dressing appropriately, even for Zoom. I'm telling you, it matters. It just does. When I'm in mediation with defense, I go, what do you think about this witness? What do you think about this plaintiff? How does she rate? Is she 5-star, 4-star, 3-star, 2-star? What is she? No star? What is she or he? And if it's a 4 or 5-star plaintiff, I get more money from the defense. I go, this is not your ordinary plaintiff, is it? No, it's a school teacher. She makes a nice appearance. She's been working for 30 years. She's perfectly lovely. Right. She's a good plaintiff. People are going to like her. They're going to relate to her. Right. And she's dressed appropriately. Doesn't have orange hair and crazy, earrings all the way down to here or whatever, just nonsense or piercings all over. It's not helpful. It's not helpful. You can't tell me people with multiple nose piercings get more money than people with no nose piercings. I refuse to believe that nose piercing is a successful mediation strategy. It just doesn't make any sense to me. And you're just making it harder to get the money that you need to get from those folks, in my view. Okay. I'm probably gonna get hate mail on the nose piercings, but whatever. Equal opportunity offender. Okay. So in preparing your client for an offer they don't like, if you're a contingency fee plaintiff, explain that they can talk outside the earshot of the mediator, and then discussing what happens if we don't settle. What's that going to look like? How long is it going to take? One of the things I find kind of humorous, because it happens on both sides, is both sides always underestimate how long it's going to take. They always do it. Nobody overestimates that. They always underestimate that. We're on the trial docket in August of 2021. Well, you're not going to trial in August 2021. Your case is a 2020 case. You're not going. There's a whole backlog. You're not going. You're probably not even going until 2022, maybe 2023. Now we have these new case management orders coming out that are supposed to change that. But in the absence of those kinds of things, it's going to cost more money than you think. And it's going to take longer than you think. And one of the things that one plaintiff's attorney told me early in my career, which I always remember, it's a line I always like. He goes, you got to understand, David, time is the plaintiff's kryptonite. Time is the plaintiff's kryptonite. No matter how bad the case is, no matter how difficult the case is for the defendant, no matter, the defendant's dead in the water, they got bad liability, they got big damages. Ultimately, though, the defendant decides when the check gets cut, not the court. The defendant decides when the check gets cut. So you always have time leverage. No matter how bad your case is to defend, you have the leverage of time, and that is kryptonite for the plaintiffs. That's why they take that, because they want to take the money. 2 or 3, 4 years down the road. Most people do not like delayed gratification. Don't call studies on delayed gratification. People aren't into that. They're not. They want it now. That's why they're willing to take a haircut. So time is the plaintiff's kryptonite. That's one of the themes that I always introduce in my letter. I always introduce that theme when I write my letter to the plaintiff's side. When I used to be a lawyer doing stuff like that, I would always talk about time. And then the other thing I always talk about appeals, because no one talks about appeals. No one talks about appeals, which is sort of strange because, if you get a big verdict, what's going to happen? The other side's going to want to appeal. And the interesting thing is it's a problem of ignorance on both sides of the V. When I was in the defense world for most of my career, the defendants, and you do suit reports either to the client or the carrier, whoever it is, they never say in any of those suit report forms, and I don't care if it's AIG, Zurich, or Walmart, or whoever it is you're representing, whatever corporate, trucking company, whatever it is, they never say in the report, what is the likelihood of an appeal arising from a trial of this case, and how much would an appeal cost, and how long would that take? And if you don't factor in appellate risk as a plaintiff or defendant, you're missing part of the decisional analysis, because if you're a plaintiff and you have a $100,000 limit and you get a verdict of $300,000, which is the case I was mediating the other day, guy says, I'm going to bust through the limit and they're going to have a problem. Well, okay, if they bust through the limit at the trial, what's going to happen? Well, they're going to have to appeal. They're duty bound to appeal. If it's a carrier, they're duty bound to appeal. You can't just jettison your limit and then leave the insured adrift with an excess verdict. You can't do that. You have to appeal under the law of Florida. It's a failure to appeal is a species of bad faith. So you're obligated to appeal to protect your insured's interests. So I go to the plaintiff's attorney and I go, you don't want a $300,000 verdict because you're going to suffer an appeal. What you want is like $1.50, $1.25, where they'll pay extra contractual to be done with it, but not so. The verdict's not so much that they're motivated to appeal. You want the Goldilocks zone, north of the policy limits, but not so high that that they're going to have to be motivated to take an appeal. You start thinking in those terms, right? So managing the expectations of the client becomes hugely important. And thinking about appellate risk is one of those overlooked things at a plaintiff or a defendant that you need to have a conversation about. All right, let's shift gears. We're talking now about opening statements in the joint session. We've already written a letter to the plaintiff, or the plaintiff has written a letter to the defense or multiple defendants. So you've already set forth some of your themes, some of your ideas, some of your major bullet points. And get outside the four corners of litigation. Talk about time, talk about uncertainty, talk about the impact of a verdict on if you're a plaintiff, talk about the impact of the verdict on the defendant. Maybe it's a not-for-profit. I did a lot of not-for-profit defense work. You know what not-for-profits don't want? They don't want any kind of judgment or order that says they did anything bad. They're deathly afraid of any adverse judgment that may involve some species of moral turpitude, right? If it's a slip and fall, not a big deal. But if it's any kind of breach of fiduciary duty, sexual harassment, discrimination, anything that has a moral tinge to it, not-for-profits are loath to go to trial. Because why? Because their donor base gets queered if they get the judgment against them for those sorts of things, right? Catholic Church is a good example, where they got hammered. So when you litigate with not-for-profits, it's a different kind of conversation sometimes. And so your opening needs to be a little bit different. Think about, who am I talking to? What are their pressure points? A couple other things, and this is for the defense bar. Oh, that's true for the plaintiff's bar. Insulting the other side in opening is not usually a very good strategy. I don't see it work. It doesn't engender people to open up their checkbook or compromise if you pissed them off in the first 30 seconds of the opening session. Yet I see it a lot of times from younger lawyers who want to, throw their weight around a little bit, who are just, and there's just there's a small percentage of the bar where they're just cranky, cantankerous, obnoxious people. They'd be that in any profession. It's just the legal profession rewards that behavior to a certain extent. But they'd be the same way if they were in any other field. And you got to neutralize that as best you can. The way I do it is, if they start hollering or hammering, or as a mediator, I shut it down. If the mediator doesn't shut it down, and I'm on the defense side, I shut it down on the defense side, because I just cut them off preemptively. I say, I'm not going to sit here and listen to that. I'm just not. I'm not interested in listening to that. My point is, a respectful opening always pays more dividends than an insulting one. And I had a case where the plaintiff was she was sketchy. That would be charitable. Okay. Malinger, liar, whatever. We had proof of lying, inconsistency, just bad lady. And the defendant didn't say anything about the lying in the deposition, didn't say anything about the wrong interrogatory answers, didn't do any kind of cross-examination type stuff. Very respectful, talked about the case, talked about his client, talked about how much you want to resolve the case, said nothing bad. And the plaintiff's attorney came to me after the opening session during the first caucus. He goes, David, you got to thank Brian, or whatever his name was. You got to thank Brian for giving such a respectful opening, because I thought I was going to have to peel my client off the ceiling. He's making it so much easier for me to settle the case. Right. How smart is that? It's the elephant in the room. Don't talk about the elephant. If you're a malingerer, you're a malingerer. You're a liar. You're a person of low character. You do. You don't need to be told that in the mediation. It's not going to be helpful. People know themselves. They do. They do. And so pointing it out is just not very helpful. The other thing you got to do in opening session is, don't look at the mediator, talk to the decision maker. Look across the table at the person who's got to decide the case. If I'm a defendant, defense counsel, I look at the plaintiff. I don't look at the plaintiff's attorney very much. If I'm the plaintiff's attorney, I look at the checkbook. Who's got the checkbook? That's the person I'm talking to. Find out where the checkbook is in the room and talk to that person. A couple other things I need to mention about opening. I had this comes up every 15, 20 times I mediate. Somebody's maybe committed some malpractice, and the plaintiff says, well, you missed the discovery deadline for expert disclosure, or you missed this, or you didn't do that, or you didn't raise this defense timely, or the defendant brings up something to plaintiff, that cause of action is barred by statute of limitations. Basically, what you're talking about, the undercurrent of what you're talking about, is some species of malpractice. Don't bring it up. If you bring up malpractice by the lawyer in front of the client in the mediation, you're creating a huge conflict. You're creating a huge conflict, because now the client's wondering whether the advice is being given to settle the case is intended to get yourself out of the soup from a malpractice standpoint, or whether you legitimately believe the case should be compromised. You see the problem you create? You mentioned malpractice. You can't do it. And young lawyers make that mistake. They do, because they're all, you want to get one over on the other side. And what's better than when they blew a deadline, or they missed something, or they forgot something? What better than to sort of hammer them with that? Like you think it's going to make him compromise the case. Well, it might make him compromise the case, but it blows up the mediation potentially. So what you have to realize is it's priced into the value of the case. It's priced in. The plaintiff's attorney, if he or she committed malpractice, has priced that into their evaluation. So has the defense. They've priced it into the evaluation if they're in trouble. It's priced into the evaluation. So you don't have to mention it. It's not a good strategy to mention it. You might mention it to the mediator and say, does the other side know this? And yeah, I'll have a conversation if I have to outside the earshot of the client, but I'm not going to ever bring up malpractice in front of the client during the opening session. It's just not a good idea. Potentially problematic. Okay. How can the defense make the mediator work for you? You got to educate me in advance. You got to indicate a willingness to settle, not fight. Right? You got to be a friend to the process if you're a defendant. That's how you get leverage. If you're loud, obnoxious, cantankerous, we're going to go to trial. We just want to go to trial. Why are you telling me all these things? You know this case is not going to go to trial, right? I mean, less than 1% of the cases are going to trial. So when you do this peremptory saber rattling at the beginning of the case in the mediation, I'm just looking at you like, well, you obviously don't know anything about statistics, do you? You clearly don't understand statistics, because the volume of your voice does not affect the likelihood with which you're going to go to trial. It doesn't. You're not going to trial. I've started telling people this in the mediation. It kind of singes their ears a little bit because we know statistically you're not going to go to trial. You're a statistical outlier if you go to trial. And plaintiffs don't know that, because when plaintiffs watch television or they read a book or they watch a movie or something on Netflix or whatever they're watching, if it's if it's legal related, right? What's happening? They're in a courtroom and they're going to go to trial. No one shows mediations on television in the movies. There's no movie about mediation. It'd be really boring. Okay. It doesn't happen. So the whole body of American citizens believes their case is going to be resolved by trial. So when you go and you tell them your case is not going to go to trial, you're almost for sure not going to go to trial. It's a mind bender. It's a mind bender because their lawyer never told them that. I guarantee you the lawyer said at the beginning, there's no chance we're going to trial. It's virtually no chance. I mean, it's 1%. Nobody says that because it's too hard for the plaintiff to, because then what happens is they have to own the case, right? If the jury's not going to decide the value of your case, who's going to decide the value of your case? You, the plaintiff, and your attorney. You have to own your own problem. You have to articulate the value of your case to yourself. How hard is that? If you've never done it before, how do you know what your case is worth? You have no ability to gauge your own case. You're counting on the jury to do it. Then we come to mediation and we say, well, you have to decide how much your case is worth. And the plaintiff goes, well, what do you mean I got to decide how much it's worth? Don't you, the mediator, do that? No, I don't do that. I don't do that. You have to figure out how much your case is worth. That's a really hard thing to do if you've never done it before. You know, lay people don't have the ability to engage in that kind of intellectual algorithm for the most part, unless you're a pretty sophisticated corporate client. So mediation is really hard for people, lay people, really hard for people. It's not hard for adjusters because they're professional claims handlers, but it's hard for most people because they don't know how to analyze risk. They don't know how to assess risk. And all during the litigation process, are they assessing risk? No. Are they thinking about the value of the case? No. Maybe they're answering interrogatories, they're gathering documents, they're doing all the perfunctory, machinery of they're servicing the machinery of the litigation as it bumbles toward what they think is going to be a trial conclusion, which is never going to happen. So they never think about the value of the case. Then we plunk them down in mediation. The first thing the mediator says is, well, today's the day you have an opportunity to seize control of this process and decide how it ends. Really? When did I learn how to do that? When did I learn how to value a case? Never. Did my lawyer talk to me how to value a case? No. So it's really hard if you start thinking in those terms, why it's such a emotional and mentally challenging prospect for a client to figure out what the value of the case is if they're a plaintiff. That's why you got to start educating them early. That's why you write those letters to the defendant. That's why you solicit a letter back from the defendant, because you want your client to read all the bad things about the case that the defense lawyer puts in the letter, right? So he can start thinking about, how do you evaluate this case? They don't have the skill set to do that. Okay. So we don't use words, and you write the letter to the plaintiff, don't use words like specious or frivolous. If you're saying somebody's taking a specious or frivolous position, you're accusing them of unethical behavior, because asserting a specious or frivolous position is per se unethical. So when you accuse someone of unethical behavior in a letter, you're just going to tune out. The rest of your argument just kind of goes out there. You can call it weak. You can call it difficult to prove. You can say it's, very difficult to overcome, likely to be unsuccessful. There's lots of ways you can couch that same comment without using grenades, verbal, linguistic grenades like specious and frivolous. And this is not, again, this is not something you just don't do that. It's not helpful to the process. If your defendant offer an apology early in the process, even before you get the mediation, there should be an apology out there. We get into hour-long debates about this every time I bring up this subject. We could do a whole seminar on apologies, how you do them, when you should do them, if you should do them, why you do them, what's the value. But all the data, if you read the social science, all the data says apologies are great. Apologies work. Apologies make a difference in the mind of the plaintiffs. So why wouldn't you use that? It costs you nothing. It costs you nothing. And it gets you leverage, it gets you a better temperament, it gets you the opportunity to sell the case more cheaply. They've done this particularly in the hospital setting where hospitals have had bad outcomes, and they've got in with the parents and offered apologies very early on and got those cases resolved for a fraction of what they might otherwise have to do. All right, did I cover anything else? Okay, and then what's that question?
Yeah, there was a question, and it kind of gets back to a point that you were talking about just a moment ago. If a defense attorney doesn't address the parade of horribles regarding truth, veracity, malingering, should the mediator address those in a private caucus? How should they be handled?
Well, I mean, I think you can address the parade of horribles regarding the fact that there could be two truths, the fact that not everyone's going to believe you, but it's the choice of language, right? I'm not sure everyone's going to believe that version of the fact. Not saying I'm not going to believe you that you're lying. I think there could be someone else might not believe that, or they might not accept that because of this fact, because this doctor's going to say this, or this expert's going to say that. There's a way to say and I say this all the time as a mediator, there's more than one truth. There's a defense truth, the plaintiff's truth, and whatever the jury decides to be the truth. Those are the three, right? Your truth is not the only truth. That's one way to get to that, right? And it's just a question of language, so much about language and tone, because if you're a defendant and you've been watching TV, what do you think the defense counsel is going to be like? He or she is going to be kind of hard, kind of tough, kind of abrupt, not empathetic, an Autobot kind of a thing. That's the picture, that's the stereotype that you think of. And when you come in and you're personable and you're warm and you relate like a human being, right? It changes their whole thought process about what's going on here, and it gives them hope that maybe something gets done. Really important that you not be your trial guy in the mediation process. Trial guy is not mediation guy or lady. Not the same body, not the same person. It's not the same person. If you want to get the case resolved, that's the thing. You got to want to get the case resolved too, right? Okay. And then brainstorming in the mediation process. If you can't figure out the direct way, maybe there's some indirect ways to get this case resolved. Maybe there's something else we can do, and just sort of brainstorming. And that's where the subject matter helps. Subject matter expertise sometimes helps, as people will come up with a different idea. How can we get this case resolved a little differently than maybe we thought? Okay. What else do I want to talk about? Let's see what else. Okay, sorry about that. My slideshow for some reason just gets stuck. Let's see what's going on. Okay, a couple of things about sort of malpractice 101 and mediation. And this, we're shifting gears in a big way here, just sort of odds and ends of malpractice related stuff. So I do a lot of teaching for Florida Lawyers Mutual Insurance Company. And I did legal malpractice when I was in practice. So I kind of had this sort of default, like, where's the error, And I was an appellate law clerk. So my whole life has been about screw ups, right? Because that's an appeal. So I always look at the process through, like, where are the screw ups? Where's the potential for screw ups? This is a topic that's kind of near and dear to my heart. This is the problem of when you create the mediation settlement agreement. Is that agreement the entire agreement between the parties, or is there a separate, more complete settlement document, release, et cetera, that's going to be prepared later on? And this is a subject of some debate among mediators. I call it the Friday afternoon mediated settlement agreement. It's the short form. It's the 1 or 2 pager you put out. Defense going to pay plaintiff how many days. Plaintiff's going to execute a release. Some other parties are going to be released as well. There'll be confidentiality. It's just a bullet point, basically, of what the longer deal is going to look like. And the writing itself says the release is going to be prepared by the defendant and given to the plaintiff for execution, and the plaintiff gets paid after she signs the release. Okay. Is that an agreement to agree? In other words, is that Friday afternoon paper that everybody signs, is that an enforceable document? I say no, because the case law agreement to agree says if you have a writing that contemplates the creation of a second writing, which in and of itself must be agreed, must be mutually agreed, then you don't have a deal until the second writing is mutually agreed and executed. Seems pretty common sense to me. There's nothing remarkable about that proposition, right? So if my settlement agreement says we're going to make another longer settlement agreement with all the bells and whistles, I say there's no deal until that second document gets signed, which means everybody has a chance to get out. That's right. That means everybody has a chance to get out from under. That means what you did on Friday is not legally binding. People don't like that answer. People don't like that. And I know why they don't like it, because everybody wants to hold everybody else's feet to the fire. But what I'm telling you is I've had cases blow up on the second paper. I've been in those cases where the second paper didn't get agreed. It was a complicated IP case and we couldn't agree on the form of the license, or it was a construction defect case and someone was trying to carve out some other claims, whatever, or there was confidentiality language no one could agree on. Whatever it was, the second agreement blew up and we couldn't get the release signed. And then someone wants to file a motion to enforce settlement. File a motion to enforce settlement and then argue that this 2-page document that we signed on Friday is a deal. In Dave Henry's court, motion denied. You don't have a deal. Now, there are mediators who will disagree with me, and I think they're wrong. I'm just saying, I'm 57 years old. I don't even try to be politically correct anymore when it comes to this stuff. I just say they're wrong. They haven't read the case law. Okay. If you have a writing that contemplates another writing, you have an agreement to agree by definition. Okay. So that first document's not executable, not enforceable. So what you do is you bring the terms of the settlement documents with you to the mediation, and you do the settlement document that day, or get it done in advance and plug in the numbers at the end of the day. That's the better, safer, I think, legally correct way to settle a case. All right, rather than relying on a 2-page cheat sheet, essentially. That's a summary of what's to come later on. That's a big problem, I think, and it happens. Every once in a while, you're on one side of it or the other, or I get a call from one of my mediation participants who said, well, they're trying to tell me that, we have a deal on Friday. I go, if you ask me to testify, which I won't, but if you ask me to testify, I'll say you don't have a deal on Friday because it contemplated a release. And you guys didn't agree on the language of the release. It's just that simple. It's not any harder than that. You have agreement that contemplates a later writing that has to be agreed. Now, if the later writing is a perfunctory writing that has no real meat to it, like the agreement says, and you're going to execute a quitclaim deed within 120 days. That's not an agreement to agree, because a quitclaim deed is a perfunctory thing. There's nothing to argue about. We know what a quitclaim deed looks like. Okay, there's no dickering about that. It's just a quitclaim deed. It's so well known and obvious and clear and unambiguous that we don't have to argue about that. Okay, a couple other things. You can't lie and make misrepresentations during mediation. People don't know that the prohibition against misrepresentation of facts and law applies in the mediation context. You can hedge, you can puff, you can say, I think I can get an expert who will say blah, blah, blah. I think I can get an expert who will say blah, blah, blah. That's fine. What you can't say is, I got an expert who's offered an opinion that blah, 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 unless you have that opinion in your pocket. You can't do that. You can say, I can go get that. I think I can get that. So lying about damages, lying about witnesses, lying about certain facts, right, that are provably false or not, or true or false, that is a no-no. Puffing is okay. And then, of course, sometimes have the problem of meeting with multiple plaintiffs where they're fighting over a fixed sum of money. Have that sometimes in these low limits cases where there's an automobile accident, 10-20 policy, and the attorney's representing 2 claimants in the same car for a limited pot of money, potential malpractice problem. And then failure to investigate confidentiality and privilege issues in other jurisdictions. So once in a while, you have to go out of state to mediate. And I've written a whole blog piece on that. I cite it in the outline material here. Understanding that Florida has very robust confidentiality and privilege rules. We have some of the best mediation infrastructure in the country. If you go to other places, the rules of engagement are going to be different, and the authority of the mediator is different, and the things that the mediator can report to the court can be different, right? And so you can run yourself into some serious problems if you don't understand confidentiality when you travel outside Florida. Do not assume that the rules are the same. Do not assume that. I had a case once where they said it was a complicated marine yacht boat slip dispute, pretty high dollar stuff over access to a harbor, slips and dock slips. And I was flying up to do the mediation as a representative of the defendant. And I talked to the mediator in advance to find out what the lay of the land. And he goes, yeah, this is scheduled from 9 to 11. I go, what? He goes, yeah, these mediations from the court, they're 2 hours. I go, what do you mean 2 hours? Who sets a 2 hour mediation in a case involving, 6, 7 figure numbers? Well, that's what we do up here. That's what we do up here. My head almost exploded. I go, you got almost no chance of settling this case within 2 hours. Well, that's how we do it. So I had to work very hard to get them to do all-day mediations, like unheard of. Like an all-day mediation, you have to be kidding me. It's called Maryland. It's not Estonia. It was freaking Maryland. Can you believe that? And then they wonder why they got a backlog of cases, because they're a bunch of nitwits. They're ADR nitwits if they're having 2 hour mediation set by the court. Why does the court care how long the mediation is? The court's not paying for it. Well, why do they care if it goes 3 days? Who cares? There's this kind, you see, I'm getting a little agitated. Maybe I need to chill down. Maybe I shouldn't have had so much coffee. Maybe I need to go to decaf. This drives me crazy. I don't know what it is, but unexamined habit and ritual drives me nuts. Tell me something that you do. Why do you do that? Because we've been doing it that way the whole time. My head wants to explode. How do you know that's the optimal process? Why is that the best way? And I go, well, in Florida, we have mediations all day, all the time. Well, we don't do that here. Okay. They also had rotating judges. So when you came up for motion practice, you never got the same judge at the same time. Talk about a dumb court system. And that's just dumb as dumb gets, right? You never had the same judge in the file. It's just crazy. Anyway, I go on a rant. That's my rant. I'm sorry, I'm ranting. It's all part of, hey, you get 2.5 hours of CE credit for the rant, so don't complain. It's fine that way. Okay. Can't really complain. It's free. That's another reason why you can't complain. Okay. You can't complain about the content. All right. We're stuck. Mediation is not going well. We can't seem to bridge the gap. This is just a hard problem. No one's contributing. It just doesn't look like it wants to happen. What do we do? All right. If people aren't settling a case, think about it this way. It's usually because somebody has access to information the other side doesn't have, or somebody's harboring under a set of facts or beliefs that aren't necessarily true. Because you think about it this way, we have a set of facts and issues and laws, and we know what the substantive law is. We have a fair understanding of the facts between us. We have a whole body of shared information, not all of it shared, but a whole bunch of the information shared between both sides. If you have lawyers of reasonable skill and intelligence, right, and they look at the facts, they look at the law, shouldn't their evaluations of the value of that claim be pretty close? Shouldn't they be within some sort of range, statistical range, 1 or 2 deviations from the norm or whatever it is, right? I look at this case, look at the injuries. We go, this case probably is worth between $300,000 and $600,000. Right. Now that's a pretty big delta, 3 and 6. But if one side says it's 100, and the other one says it's $1,000,001, that's a huge delta, right? Why would that be? How can it be that reasonably intelligent people armed with the same facts, knowledge of the law, et cetera, have widely disparate views of what the case is? Somebody's got information the other side doesn't have, or somebody failed to communicate information that they should have communicated, or somebody's withholding. It's an absence of information problem, typically. It can sometimes be a law problem if they don't understand the law. Sometimes we get, and as a mediator, we always try to push back that, because if you get arguing the law in mediation, you're sunk. You're just sunk as a mediator, okay? You just are. So we always got to make sure we understand what the shared law is that governs this case. And once we get through that, then we're talking about the information, the facts, and the data. And if we all have access to that information, we should be somewhere within the orbit of each other, right? Right? And if we're not, that means what you have to ask yourself, what information don't I understand? If I'm a defendant and I'm offering 100 and the plaintiff's demanding 1.1 million and he won't get off $1 million, what am I missing here? That's always a good question to be asking the mediator and asking the other side. What is it we don't know? Let's go back to the beginning and figure out what is it we don't know. All right. That's really important. And then the other thing to think about is there some other way we can resolve this problem? Or can we resolve part of this problem today? I've had construction cases where we got 3 or 4, 5, 6 different carriers, and they're all jockeying for position about who's going to pay what. The plaintiff's not even the problem. The problem is in the defense camp, because these knuckleheads can't argue, but can't decide between them what the proportional share should be between sub, contractor, architect, engineer, framer, whatever, plumber, whatever it is. They can't collectively get their act together, which is one of the other bullet points we talked about earlier, which was you got to have an intra-defendant conference before the mediation among the defendants to make sure everybody's singing from the same hymn book, pretty much. because oftentimes in multi-party cases, the thing goes off the rails, not because the plaintiff's being unreasonable, it's because the defendants can't get their collective act together because they didn't talk before the mediation. And then they find out, the one that you thought was going to pay 50% only wants to pay 20%, and they're expecting you to pay 50%. I go, no, I'm the 20% guy. You're the 50% guy. And they're 10, 10, 10. No, Dave, you had it all wrong. You're the 50% guy. You can't have those kind of conversations in mediation and expect to settle the case. That kind of caucusing has to take place before the mediation. So if you get into those kinds of conversations during the mediation process about who's going to pay what proportional share, somebody doesn't have all the information. Somebody needs to share the information, and someone's got to start explaining their thought process, right? So in those kind of cases, maybe we just eschew traditional settlements. I'll tell you a little strategy I've done multiple times, and I'll give it to you. It works almost every time perfectly. So I've got a multi-defendant case. I'm having a hard time getting an opening offer going from the defense. The plaintiff's at $2 million. I'm thinking this case is going to resolve for about $1 million. Not hard math. He's asking for $2 million. It's probably going to resolve for $1 million. I can't get these knuckleheads to agree on the first $100,000. How are we going to pay the first $100,000? Who wants to? Is it a third, a third, a third? Is it quarter, quarter? What is it? They can't agree on any of that. So I go, guys, we don't have to agree on any of that right now because it doesn't matter. Because when we offer $100,000, everybody in this room knows it's not going to be accepted. Correct? It's just a conversation starter. Correct? Yes. So if it's not going to be accepted, we don't have to worry about the apportionment because no one's going to be asked to pay it. We just need to get back in the other room. So just give me $100, give me $100,000 of monopoly money. I'm pretty sure if the plaintiff took it, we could figure out a way to split the $100,000, right, guys? Yes. So we just go with monopoly money. I do monopoly money. Okay. Now at some point it stops being monopoly money, but I can go $200,000, $300,000, $400,000, $500,000 of monopoly money undifferentiated. Okay. And eventually someone's going to blink and someone's going to start making demands about proportional shares. But for the first 2 hours, I don't care what the proportional shares are. You can talk amongst yourself when I'm in the other room, but it's not my problem for the first 2 or 3 hours. But so why are you making this a problem now? Why am I spending all my time in the defense camp when what I really need to be doing is getting the plaintiff's camp and trying to leverage them down to a number that you like, right? So I call it the funny money. It's funny money. It's just make believe money. And there's always somebody in the audience or in the group who says, I don't like that. Why don't you like that? Because of unexamined habit and ritual, because you haven't done it before. I moved your food bowl to the left and you can't find it, right? I moved your food bowl 6 inches and now you're all hacked off. Get over it. Okay. This is how it's called a creative problem solving. That's what we have to do sometimes. We have to think of a different way to get there. All right. Or maybe we just work out a deal where we come up with $1 million and everybody reserves their claims against each other. We just put $1 million in the pot and everybody can reserve their right to contribution back against everybody else. We take the plaintiff out of the equation. Done that kind of a deal too. I've done litigation loans between carriers and insureds where the carrier paid money on behalf of the insured to settle the case, reserving its right to litigate coverage. And we put a high-low in place, so the defendant was going to pay back the insurance company some amount of money if the carrier won on their coverage position. But we didn't want to litigate the underlying case. We want to get that to bed. So we put the coverage litigation in a box over here. We said, we'll resolve that later. Let's take out the catastrophically injured plaintiff first, and then we'll figure out what we do later on. Some people will do that occasionally. So, and then what would it take for you to accept X amount of dollars, or what does that really look like? Or what would you do with, here's a good question. What would you do with the money? I always like to ask plaintiffs that. What would you, because then it makes it real for them. Like, what would you do if you got $50,000 today or within 20 days? There's going to be a check coming to you within 20 days for $50,000. What would you do with it? You start putting it in those kind of concrete terms, it's very helpful in the plaintiff's camp because then it's not an abstraction. It's a reality. It's like, yeah, maybe I could get a judgment for $300,000, but it's $50,000. What would I do with $50,000 a day? Turns out I do a lot with $50,000 a day. And so making it concrete to the parties is very realistic. It is very helpful, I think, in resolving the case. Okay, a couple of comments about settlement agreements. I hope if I got everybody's questions, I hope I'm not missing any questions. You're monitoring the chat there. Let me see what's going on here.
Yeah, David, they did have a question about the mediation agreement. And I think it gets to what you're talking about now, the settlement agreement. You talked about, having the agreement to agree. Right. And then the question here is, could you have a paragraph in the mediation agreement, that first document, stating that if the parties can't agree on the second document, there is a final settlement based on the first document?
Sure, you could put that in. Sure, you could. Sure, you could. Yeah, you could do that. You could say this is the end all unless we create another writing, and we create another writing and that other writing governs. You could do that. But as a defendant, you're not, because you got to get all that release language and all the hoo-ha and the Medicare set aside, the indemnity. As a defendant, you can't agree with that. The carrier's not, if it's a carrier, they're definitely not going to want to fund that deal if it leaves open somebody else. Maybe you need releases for officers, directors, employees, agents, blah, blah, blah. There's just a whole level of protections that you need as a defendant in a longer release document. The plaintiff doesn't normally care. They're just going to get money. They don't care about the release, but the defendant oftentimes cares about the release a lot. So that's a problem. So you got issues like tax consequences and indemnity, Medicare set-asides, all those sorts of stuff that you got to be thinking of. One other thing, here's a little secret. I'll tell you, it's a little mediator secret. I shouldn't be telling you guys this stuff. I think if the ADR committee told you, if they knew I was telling you guys stuff, they'd probably kick me off. So one of the little things mediators do is we forget stuff along the way. So you bring up terms early in the day, but they're like non-economic terms, like I need this release over here, or I'm going to want a confidentiality provision, or we're going to want them to take down a sign, or whatever non-monetary thing or whatever it is, kind of doesn't seem hugely important, because if we don't get the money agreed, the rest of it doesn't really matter. I forget about that stuff on purpose. I forget about it on purpose because I don't want to get caught talking about that stuff. Now, if you're a smart lawyer, what you do is you look at your notes and you circle back. And as a mediator, I should do that too. I should circle back at the end, right before we sign the documents, go, now we did talk about this. But sometimes I'll just forget stuff because you brought it up in the first hour and no one's talked about it since. Must not be that important to you. So I will purposefully ignore stuff. That sounds a little awful. It's like malpractice. It's not my job to make your agreement. I'm not the policeman of your agreement. I'm a facilitator. I'm not the draftsman. In fact, there's a MEAC opinion now that says you shouldn't be drafting a document whatsoever. It creates problems because there've been some apocryphal stories where mediators have stuck terms in the agreement because they were, quote, customary, that the defense didn't want in there, or somebody didn't want in there. They purposely didn't want to talk about that. And the mediator, he's drafting up his Friday afternoon mediation settlement agreement, put stuff in there that the other side specifically was trying to avoid. So the MEAC opinions say, don't draft the agreement for the parties. I'm not the guy responsible for all the terms. You're responsible for the terms. So check your notes. I will tell you, I will do that. But there have been occasions where I'm like, do I really want to bring this up? Because this is no one's talked about it for 6 hours. Do I really want to bring this up? So the question I'll ask is, here's how I get around it. I go, everybody, look at your notes over the last couple hours and think real carefully about whether there's something else that needs to be in this deal. That's my get out of jail free line. Is there something else that needs to be in this deal? And that puts the onus on the lawyers and the clients to remember the other stuff that they were talking about. It's not my problem to police your agreement. Okay. What else? Non-parties. So sometimes non-parties need to be included in the agreement too, and you got to think about that. All right, maybe it's a franchisor or franchisee, maybe it's an additional insured, whatever it is. Be mindful of that along the way with the settlement agreement. Okay, what else we want to talk about? Let's see what else we want to talk about. Okay, some concluding thoughts. So we're ending on pretty good time here. All right. The title of this presentation was Inside the Plaintiff's Caucus Room. But really what you have to think about if you're a plaintiff is you got to think about what's going on in the other caucus room too. What do I need to do to motivate them to pay me some money? Make your plaintiff distinctive, particularly in your sort of undifferentiated personal injury claims. Or what is it about this case that you, the defendant, don't really appreciate? Find something that makes your claim, your client, your damages, your scenario unique or distinct. Distinctiveness matters, right? It's like in trademark circles, you have to have a distinctive mark. Otherwise, if your mark is sort of generic or boring, people don't remember it, or they confuse it with other things, right? You want to have a distinctive, you want your case to be like its own brand, right? So this is an interesting case. It's different. It's funky. It's not just a regular rear end case. It's not just a regular construction case. There's something about this that makes it different or weird or strange, and that gets people's attention. Drafting and soliciting a pre-mediation letter. If there was one thing that I could do, oh, I'm sorry, it just punted on me. If there's one thing I could do if I was Lord King for a day, I would put in the rules that everybody has to write a letter to the other side before the mediation. You got to write a letter to the other side. It's your one opportunity to speak directly, unfiltered to the plaintiff. What is such an opportunity? Because in the regular litigation process, you can't talk to the plaintiff. You can't talk to the defendant. You have to talk through the lawyers and you file motions and papers and stuff. There's no actual communication, right? In fact, in litigation, we tell everybody, don't talk to the other side. We don't talk, don't call them on the phone, don't talk to them. That's common advice, right? We don't want the clients talking to each other outside our earshot or even at all. We do the talking for you. We handle all the stuff. Don't talk. So then we come to mediation. What are we doing? We're talking to each other directly. Why not use the pre-mediation privilege as an opportunity to speak directly to the other side by thoughtful, empathetic, timely, intelligent, compassionate, letter that humanizes your client, makes them distinct. If you're a defendant, makes them seem, like a appropriate moral actor who maybe committed a mistake, right? Committed an error. It's not a moral. They're not morally turpitudinous. They just made a mistake. That kind of direct communication sends a real message to the layperson. It really does, because they're expecting something very different. Because remember, they've been brainwashed by TV and social media. They think they know how lawyers communicate. They think that they know what tone lawyers take. And when you take a very different tone and send a very different message, you're really being a very powerful ally for your side, right? This is not an adversary proceeding. It's not an adversary proceeding when you come to me. It's not adversarial. We are both in a boat that's going to go over a waterfall. The waterfall is called trial. Someone's going to get poured out of that boat pretty badly and get hurt, right? But right now, all we have to do is, what harbor do we got to pick a harbor, and we got to decide to tie up the boat on the dock and mutually disembark on agreed terms. We got to get off the boat together. We're on the same boat. We got to get off this boat before we go over the waterfall. Where do we go park this boat? Who wants to pay for the offloading? How much is it going to cost? How much do we have to pay the stevedore to get all the stuff off the boat, right? And that's what we're doing. And it's a very different thing than if we're in two different boats, shooting at each other. We're in the same boat. We're going to go over a waterfall unless we figure out a way to get this problem done. Beware of unexamined habit or custom-related mediation advocacy that is suboptimal. Okay, so not sending a mediation statement is custom and habit. I don't get mediation statements from the lawyers sometimes. If I have two parties, I'm lucky if I get one. I almost never get two position statements. Failure to communicate. What's that line from? Was it Cool Hand Luke? Remember, he gets in trouble in the movie. Was it Broderick Crawford? Who's the guy? No, that's not his name. It was what was that guy's name who played the ward? And I forget. He is a failure to communicate. That's what it was. It's a failure to communicate. I like this one. It only takes one ass to spell impasse. That's right. In a defense camp, if you have multiple parties, it only takes one person to blow it up. And so if I'm a plaintiff, I got to really make sure everybody in the room has a reason to settle the case. And I got to figure out who the difficult actors are going to be in advance. And you can sometimes know that from the tenor and tone that they've taken during the litigation. If they've been really abrupt and rude and hard ass during litigation, chances are they're probably going to be that way in mediation. And so you got to think about, how do I diffuse that? How do I get this guy or lady interested in paying me some money if I'm a plaintiff? Or if I'm a defendant and the plaintiff's lawyer has been really rude and obnoxious and a big pain in the ass, how do I diffuse that? Well, the way you diffuse that is you don't engage. And the way you don't engage is you don't write the letter to the plaintiff's attorney. You write the letter as if it was written for the plaintiff. Now, you're going to have to address it to the plaintiff's attorney, but you're writing, you're speaking, you're communicating directly to the plaintiff. When I had obnoxious plaintiff's attorneys against me, and I know it never happens, but let's assume hypothetically there was an obnoxious attorney against me in a case, I would always look directly at the plaintiff and I would just ignore him. I just wouldn't look at them, and they could be making faces and scowling and having a little internal hissy fit over here. I'm looking over at the plaintiff and I'm just trying to relate to this individual. That's hugely successful. It's a very small thing. It's not a big, but your natural default tendency is to look at the mediator, because the mediator is in the position of judge, sort of, kind of. You know what I mean? He's between the two parties, literally between the two parties. So he's in this sort of figurehead, he or she's in this figurehead position. So you tend to want to look that way, because when you're in court, that's where you look. If you're in court and you start arguing your motion, you're talking to the other side, the judge will admonish you. Counsel, you make your comments to the bench, not to that guy. Right, you're supposed to do that. So your habit is to talk to the figurehead in the middle, not the other side, and certainly not to the client. You don't go to court and start talking to the opposing client. You talk to the judge. So you got to sort of rid yourself of that default mechanism as a litigator and focus on who I need to talk to. Who's the most important person in the room? It's not the plaintiff's attorney. It's not the defense attorney. They're not the most important person in the room. Okay. And then plaintiff has to articulate a clear picture of damages well in advance of mediation, which is then buttressed at mediation. So one of the things when I was doing the mediation training at my former law firm, I go, guys, we all know liability is a crapshoot. We can't predict that necessarily, but what we can get our arms around pretty quickly is what are the worst case, what's the best case, worst case? What are the worst case damages that we might be made to suffer if we lose? And if you're a plaintiff, you have to be able to articulate that. I get frustrated in some of these commercial cases and I go, well, we have a lost profits claim. Okay, well, what does that look like? Well, we haven't calculated it yet. What do you want me to do with that? Well, I got to sit here and manufacture your lost profits claim for you in the caucus session. And then we take it over to the other side and say, oh, by the way, we claim lost profits. Here they are now. You're telling me now you got $500,000 in lost profits and you haven't told me this before today's mediation. Well, we answered interrogatory. What did you say in the interrogatory? Did you say there was $500,000 in lost profits? No, it said still being calculated or some BS answer in your interrogatory answers. But we told him it was lost profit. You didn't tell him how much, you knucklehead. Malpractice. You committed mediation malpractice because you didn't articulate your damages clearly, well in advance, so the defendant would know what might be the worst case scenario for them. Assume if you're a plaintiff, the defendant doesn't know everything. Assume if you're a plaintiff, they don't really know your case. Maybe that lawyer was going away to a Vegas trip. Maybe that lawyer came back from a honeymoon. Maybe that lawyer his parents were sick and he was out of the office for 3 weeks. You know, I mean, I remember when my dad was super sick a couple of years ago. You asked me what was going on in my files in March of 2019. I got no idea. Right. I think I had a mediation in April, but I wasn't on my game because I had other things to worry about. Right. So I didn't, my file was not in the same shape it would be. People have stuff going on in their lives and stuff happens. They don't necessarily appreciate all the nuances of the case. Your job as a plaintiff is to make sure you really educate the defendant as best you can. It means taking more time. It means writing letters. It means finding out who's coming. It means really working, planning this dinner party. This mediation is a complicated dinner party. It's unscripted. And you've got to do your best to make sure you got the right actors, that they have all the information they possibly could want. No surprises, right? Informed decision makers at the table. And you present a clear, cogent picture of your damages. It sounds obvious, but I'm telling you, there's so many times when I come into a case, whether it's a BI case, they go, well, they're going to need future surgery. Well, what does that cost? Well, I don't know. Well, darn it. You got to come up with a number for that. You got to come up. Is it a $30,000 rotator cuff? What is it? You got to put a number on that. And that's just lazy. Liability is always going to be debated. Unless it's clear liability, it's always going to be debated. Percentage of negligence, we don't know. It's a crapshoot. But damages, we got to really crystallize it for a plaintiff. If you can't articulate your damages, you're really doing yourself a disservice. If you can't articulate to the defendant, here's what your worst day looks like. Oh, I didn't know that. I hadn't thought about that. I didn't realize the consortium claim was pretty valuable because I hadn't taken the wife's deposition yet. So I didn't really know yet how bad the consortium, I thought it was kind of a throwaway claim. Turns out it's kind of a big issue, right? Because the wife was special needs and she had MS, and now the husband can't do the things around the house they used to do. So it creates a big problem. Well, I didn't know the wife had MS, right? Those sorts of little weird things like that. So always be mindful of, and then remember mediation. If you don't settle the case, don't worry. You can schedule another mediation. There's no rule against 2 mediations. In fact, you should have them. When I was in private practice at the end of my career for the last 10 years, it finally dawned on me. When we're doing case management at the beginning of the case, whether we're in state and federal court, let's plan for 2 mediations, not 1. Because look, listen, if we have an early mediation, we give ourselves an opportunity to get out from under chief before a defendant potentially, and the plaintiffs like that. Plaintiffs' attorneys like that. Plaintiffs' attorneys, if you're on contingency fee, of course you want early mediation. Your effective hourly rate goes through the roof if you can settle the case, within 120 days after the complaint is filed, right? You have a second mediation, you schedule down the road a piece, not after the discovery deadline, as some of these case management orders say. That's train wreck. You have the second mediation before the end of discovery, probably like 35 days before the end of discovery. So you have time to get some discovery done if you find out something new, because invariably in mediation, you will find out something new if you don't settle the case. You will find out some new witness, some new defense, some new issue, some new fact, some new expert. Something will pop up that needs to be investigated, analyzed, looked into, and you don't have time to do that once the discovery period's over. So that's one of those things that I think is just an invitation for disaster, is when we find out, oh, by the way, I need an expert on this. Well, what do you do now? Now you got to move the whole case management deadlines. You got to move the whole discovery. You got a big argument about whether it's just so much harder. You got to front load the mediation process. I know why we don't do that. I can tell you why we don't do that. There's a whole host of psychological and economic reasons why we don't do that. Okay. From a defense lawyer's perspective, well, I don't get to make as much money if we settle the case early. And that seems a little crass and self-serving, but I know that there's firms, I know to a moral certainty that there are firms that think that way. The firms that think that way. I got to get a little bit of meat off the bone before we go to mediation on this file. Some of the smarter carriers and institutional clients that have repeat business, that have a lot of litigation, they're managing their metrics now. Look, I grew up in this business for 35 years. I did all corporate and defense work, whether it's aviation, products, premises, whatever it was. So I've seen all that stuff. What's happening in the insurance and corporate America and the risk management analysis is they're getting a lot smarter than they used to be. And they're not looking at the total amount of indemnity. They're looking at the file closure rates. How fast does this firm close a file, right? And the plaintiff's bar wants early mediation, so there should be no objection from them typically. All right. So the defense bar, the smarter firms, I'm telling you they're skating to where the puck. What was it Wayne Gretzky used to say? He said, "Hockey's not hard. You have to skate to where the puck's going to be." Which I thought was so funny. You got to skate to where the puck's going to be. So if you're a defense firm and you're handling a lot of cases for institutional clients, here's where the puck's going. They're looking at file closure rates. How long is this file open, and what is our defense spend? What is our defense spend, and what's in our indemnity spend? And you know why this is so easy for them to get around, to get to? Because they're mediated settlements. You can't judge law firms anymore based on trial results. I see these firm websites. They talk about how good they are in trial. Nobody cares. Corporate America. They did a survey. Of what was it? What's that outfit called? CLA, CLS. What is it? Claims Management Institute. What is it? I forget what it's called. Somebody made me know what I'm talking about, but it's the big body of folks that get together and insurance and corporate interests to talk about managing litigation and tort reform and all that kind of stuff. I can't remember the name of it now. It's like CMS or CLI, but anyway, they did a survey of in-house counsel and claims representatives. They go, how do you choose law firms? What are the decisional criteria that you use to choose law firms? And you know what? And they said, what was it? And they said timely reporting in case evaluations, And it wasn't trial results. It wasn't, someone needs to mute their line. It wasn't trial results. It wasn't, how good your lead trial lawyer was. It was how fast could you get the cases resolved, and how well did you report? What was your reporting like? And that's what it was. Trial results was 1%. 1% of all those people surveyed said trial results is how they pick law firms. They're not picking law firms based on that. So if you're in the defense camp repeatedly, your charges, your smart play in the marketplace is to give your clients the first chance, mediate early, because a lot of lawyers won't do that, and plaintiffs lawyers love it. You become the golden child of the plaintiffs bar if you start pushing for earlier mediations, and you set a second mediation on the books at the beginning of the case. So if a new case comes in, it gets filed in May, we say, let's have another mediation. So let's have a first mediation in October or September, October, and let's have another mediation 45 days before the end of discovery. And when I mention this to the other side, I go, why do we want to have a second mediation? Because the case can change. Maybe you don't like your case anymore. Maybe I don't like my case anymore. And one of us wants to have another mediation, but if we come ask for it, it's going to look like you got your blood in the water. So, but if we set the second mediation at the beginning of the case, there's no harm, no foul, no skin, right? It's not a tell. It's not a tell. If you come to me at the end of the discovery period asking for another mediation, you're a plaintiff. I'm thinking you want to jump ship. But if I do it at the beginning of the case, we're both on the same equal footing. We don't know how the case is going to go. And if we need that second mediation, we have it in our back pocket and we can use it. And every time I suggested that in federal court, when I was doing the Rule 26 case management plan, whenever I put in 2 mediations as a recommendation, the other side always agreed. They go, Dave, that's a good idea. Yeah, it is a good idea. It's a good idea for the client. And here's the other thing. If you're on the defense side, why would you want a second mediation? What if you miss something? What if you overlook something? What if you learn something new? You give your client a second opportunity to settle the case. How can they complain about the trial bills if you gave them a second meaningful opportunity to settle the case? They can't complain. You gave them the opportunity to bail. They didn't want to. So it's malpractice insurance. It's client management insurance. It does a lot of really, really smart things. If someone's got their line open, not sure. Let me just do this. I appreciate your time and attention. Did I mute myself? Control A. Can you all hear me okay? I hope so you can. There we go. So I appreciate your time and attention. Do we have any other questions, Hugo, that I'm missing? I'm trying to find my chat bar.
Oh, we're just fine here. We're great.
All right. Any other questions, comments, observations? Maybe you disagree with me. Who knows? I might be wrong. I could be wrong about all that stuff. It's very possible. Ask my first wife. So what else? What else is there that we can talk about? We got
a question for you, David.
Yeah.
I've been to mediations where we think we resolved the claim, and then sure shooting, I get the release, and it's got a confidentiality clause in there, which, according to IRS regulations, can make it a taxable event.
That's right.
That for the plaintiff.
That's
I'm
right.
Wondering, is there a way that you particularly police that at the mediation conference so as to avoid that situation?
Yeah, the way I do it is when at the end of the day, when we got that short form piece of paper done, I go, well, what are the non-economic terms that are going to be coming on later on? Is there anything else, any other non-economic terms we need to talk about? And I ask, and here's a little trick, I'll tell you, it's very clever. And I learned this by, because I stepped on a landmine one time. I had a hard mediation. It went to like 9 o'clock. I was a defense attorney. I wasn't. It was early in my mediation career. And I brought everybody together in a big conference room at my law firm. And we were at the end of the day and we're drafting both set on paperwork. And you know how at the end of the night, when the lawyers have now resolved the case and they just kind of chat collegially among themselves, because, you know, we're all members of the bar, we got it done. And then somebody made an offhand comment about one of the witnesses in the case, just kind of attempt to be humorous. And one of the parties did not like that comment whatsoever, and it blew up the deal. Just over offhand comment. So what I've learned to do is I get the lawyers together in a separate room apart from the clients. I tell the clients at the beginning, I go, hey, if we're going to do some settlement paperwork now, the lawyers are going to go, me and the lawyers are going to go work on this for a little while. We're going to bring it back to you. We're going to go over everything with it. But right now, we just need to be alone and draft this thing up. And then the lawyers do the drafting. And during that session where I'm with all the lawyers in the room on Friday night, I say, guys, is there any other non-economic terms we need to be thinking about? If there's not going to be a full and complete settlement tonight, let's talk about what's the release on Monday going to look like? What's going to be in it? Just give me the bullet points. And let's put them in this document and say, it's going to have this, it's going to have that. And that's the only way I know to police that, Steve. That's the only way I know how to fix that, is to just call it out and say, what else is coming next week? And if they don't say anything, shame on them. And then they stick a confidentiality provision there. Now, doesn't really solve your problem because they're not bound by what we wrote on Friday afternoon. They go, well, I thought of it on Sunday. Yeah, it can happen. It can happen. And you're going to be upset and angry on Monday when you see the document, but at least we did our best to try to flesh that out in advance. I don't have a better solution to that problem other than just try to call out the non-economic terms in advance. Oh, yeah. And that monetary consideration thing, I don't know what is the answer for finagling that problem? Because in the old days, we used to say some or all of the consideration paid herein is for the promise of confidentiality. But somebody told me that's a problem. Does anybody know what the fix is on that? Do you put a stated amount in the settlement agreement for the confidentiality, or you just don't put any amount? What is the fix? I don't know.
I think the probable fix is to choose a fairly nominal amount. Now, that's not to say that the commissioner for Internal Revenue can't ultimately challenge it. And the leading case seems to be the one about Dennis Rodman. It turned out that Rodman went to chase a ball that went out of the basketball court, and he ran into a photographer, and in so doing, I guess the guy got kicked in the groin. There was some litigation, and I think it was settled for about $200,000. And they didn't address how much would be for confidentiality, but that came in the release. And the insurance commissioner got a hold of it, and they tagged him for like $40,000, $50,000, $60,000 in there.
Wow!
Because it hadn't been addressed. So probably if you put in some number, you may get it to stick. But yeah. I don't know for sure.
No, I don't. I think that's what I've been doing in some of my employment cases. Is people have been saying we're going to put a finite amount of money in there for the promise of confidentiality, and that's where we sometimes get into a haggle over how much that's going to be and whether it's going to be taxable and that sort of thing. Anybody else have any better solution to that problem? I'm all ears. I'm all ears. But I think stated consideration is probably the nominal stated consideration. Maybe that's the best fix at the time for that problem. Okay. Anything else anybody has any questions about? Anybody want to push back on anything? Question about what we need to, okay,
David?
Yeah.
I'm Ken Mastrelli. I don't know if you can see me on your screen. I have a question. I mean, it kind of goes back to something you said earlier, but it happens to me a lot. I'm a plaintiff's attorney. It happens to me a lot on mediations where I feel like, and maybe I'm just overly sensitive, but when we talk about the parade of horribles, and I always fully expect to hear the parade of horribles or the contradictions about inconsistencies in deposition or ROGs or the negative components, what they're going to tell a jury about my client. I get all that, but I sometimes get the impression that the defense is trying to like drive a wedge between myself and my client, because they'll couch things in terms of, I don't know if your lawyer has told you this, but
Yeah.
okay, immediately inferring I haven't done my job, you know, and
Right.
and it creates an immediate kind of conflict,
Right.
immediate defensive reaction. I don't know if that's, you know, I don't know if that's a strategy that like you've talked about during this. I didn't get all of this mediation, but anyway, my point is, how do you like handle that? How do I respond to that? Do I respond to it? Should I not at all?
I think you just ignore it. I think the defendants that do that, I doubt they're doing it willfully in a way to sort of to separate you from your client, because that doesn't make a whole lot of sense, because your client's going to be relying on your advice to settle the case. And if you're not going to agree to the settlement, it's very rare for a plaintiff to eschew the advice of the plaintiff's attorney and settle the case against his advice. I mean, it happens very, very, very rarely. So if I'm driving a wedge between the plaintiff and the plaintiff's attorney at the outset of the mediation, that seems to me to be contraindicated. That's not a smart play. Now, having said that, I will tell you, I've been in cases where I was convinced to a moral certainty that the plaintiff's attorney did not want to settle the case, and he was elevating his or her self-interest over the interest of his clients because it was an hourly fee case, and he was a small lawyer, small firm, 1 to 2 guy, and he needed this case to make payroll. And I knew, I mean, I can't swear to it, I can't prove it, but just the whole tone, attitude, and demeanor did not look like the guy who was interested in the case. And when that happens, as a defense lawyer, you think that's going on, then you do need to think about, well, how do I get this information in the hands of the actual plaintiff and sort of neutralize that lawyer, right? But you don't say, I'm sure your lawyer didn't tell you this, or maybe you don't say that. You just say what it is. You don't preface it with what your lawyer did. You just say it. You just get that information out to them. Here's something I think you need to know. Here's something I think you need to know. All right. Here's what's going on here. All right. And that's just, it's the first little part of what you said, comma. Your lawyer may have told you this, comma. Just eliminate the stuff before the comma.
Usually it involves like a proposal for settlement if one has been filed.
Oh yeah. And
they'll say, well, you know, I don't know, you know, we filed this, and let me explain to you what that means. And if you don't do X, I'll usually say something like, I've explained to him what that means.
Right. We get that. Right.
Yes.
Right.
Or her.
But I never mention the PFS if I'm a defense lawyer. I never mention the PFS at the beginning of the case, because plaintiffs don't have the analytical ability. Lay plaintiffs do not have the analytical ability to understand the logical implications of what that means in any meaningful way. In other words, it doesn't impact their decision making at 9 o'clock or 10 o'clock in the morning. It's not going to be part. What I do is I save that till 4:30 when it's getting close and I need something to push him over. And I go, by the way, what's your first name?
Ken.
Ken. I think Ken, let's talk about this proposal for settlement. If we don't settle today, what's it going to look like? Let's just go over that real quickly with your client. And then we talk about it at 4:30 in the afternoon. If I need a little nudge, you know, that's what I save it for the nudge. It's almost useless at the beginning of the case. It's almost useless. It's like arguing about summary judgment at the beginning. Plaintiffs don't think they're going to get summary judgment against them. Why are you talking about summary judgment at 9 o'clock?
I'm glad you said that, because that often, maybe it's just me, I hear that a lot. I'll start hearing a legal argument initially, and you know, there's a high likelihood that, you know, the court is going to throw your case out. I mean, they look directly at my client and tell me, maybe it's a fall case or something like that. And I'm like, that isn't promoting a solution here.
Because that means you should take 0, and 0 is never going to be enough. You're making the argument that 0 is a correct number, and we all know 0 is not a correct number. So the only information that means is that 0 is on the table. Okay, is 0 going to be the number? No. Today you're going to. Here's what I do. I tell defense, when I was a mediation trainer for a 500-person law firm, so I had talked to people in lots of different places, and I said, the older I got, the more I changed what I did. And when I was younger, of course, you argue summary judgment positions because you're thinking you're going to get, you know, the mediator is going to grant your motion for summary judgment and convince the plaintiff to capitulate. No, he's not, right? So what I started doing now, and it seems kind of counterintuitive, but I told my clients I was going to say this ahead of time. I would look the plaintiff in the eye and I would say, we're going to pay you some money today. Nobody says that. Nobody, we're going to pay you some money today. Now, I will tell you, Mr. So-and-so or Miss So-and-so, it's probably not going to be all the money you want.
Yes.
It's probably, I'm telling you, I'm not going to, everybody agrees you're in a lot of pain. Everybody agrees what happened is horrible. We may not agree on what the value of the case is, but please understand, we do not deny your pain, your suffering, how difficult this must be for you. We may have a disagreement about the value of your case for settlement purposes, but we're not going to deny your pain and suffering. And when I hear that, it's a good thing, because I'm telling them I'm going to pay them some money, because it's true. I am going to pay you some money. So why wouldn't I tell you the true thing, as opposed to the court's going to throw your case out? Really? What's a plaintiff supposed to do with that information? That's like basically saying my lawyer committed malpractice. Told me I had a case, but the judge just threw it out. You're just saying malpractice in a different way.
Yes.
No good. It's just no good. It's unexamined habit and ritual. It's just people say these things without examining the logical underpinning of what they're saying. And they just don't get it. Okay, well, I've taken up probably more of the time than you all want to spend, but I appreciate you all attending. If you want to subscribe to my blog, you can go on my website, henryadr.com, and I write a monthly piece on mediation advocacy, tips and strategies and ethics and all that kind of stuff. And there's some back articles that I've written that are referenced in my outline material. If you want the letter to the client that discusses the mediation process, you know, what is a mediation? I'll give you that form letter. Just ping me via email, dhenry@henryadr.com, and I'll send you that form letter that I use, one size fits all letter. Okay, I guess we're going to shut it down. Seeing no more questions. Thanks, everybody. Take care.
Thank you, David. It's excellent.